Hi, my name's Lucy and I'm a solicitor specialising in intellectual property. I've chosen to talk about the Europe-wide patent system due to launch in December 2017. The story of the European patent reveals, I think, in a microcosm, some of the complexities of Brexit for our legal system and key industry sectors such as pharma. It also illuminates the risks that the politics of Brexit pose to the coherence of our legal system, which is vital to UK-based businesses. For over 40 years, companies, including SMEs, have lobbied for a Europe-wide patent. In response, UK, French and German practitioners have developed the unified patent, and it's finally due to become a reality across Europe at the end of this year. It aims to make protecting inventions easier and cheaper by creating a one-stop shop for patent protection and disputes. It will place patents in the same position as other registered rights such as trademarks and designs, which also benefit at the moment from Europe-wide protection and enforcement regimes. At present, only member states can participate in the Unified Patent Court, but it is not an EU institution, so there is a possibility that perhaps an amendment could be made so that the UK could participate post-Brexit. London is set to be the home of the court's specialist pharmaceutical division, and this was a prize won in part due to the presence here of the European Medicines Agency. In November, despite Brexit, Baroness Neville-Rolfe, the Minister of State for Energy and Intellectual Property, indicated that the UK will still ratify the relevant treaty, the Unified Patent Court Agreement. And the system is particularly important to pharma, which we know is a government priority for Brexit. It includes, however, a necessary role for the Court of Justice of the European Union. And so recently, UKIP's Douglas Carswell and the Daily Mirror have declared the system to be unacceptable for post-Brexit Britain. Meanwhile, other member states are also eyeing up the prestigious pharmaceutical division. The political demonisation of the role of the court disregards how the UK has created this international system and how such systems always need a court to interpret consistently the law that they apply. And it also ignores the system's benefits to companies based here. The majority of these companies operate across the continent, and the Unified Patent Court is going to be relevant to them whether or not the UK is in the system. If the UK is in the system, then we remove a UK layer of cost. We simplify enforcement or revocation of patents, and we give pharma companies and others a reason to keep significant bases here. If we're not part of the system, pharma companies may not even seek to apply UK patent protection for some of their drugs, especially when combined with the fact that the UK is an expensive place to litigate patents, and once we're out of the regulatory regime for drugs that Europe has, then some of the drugs may not be approved as quickly as they currently are. As advisors, we're unclear at present how to advise companies of our future role within the system, and so we await to hear what that role will be. Thank you.